Hello, everyone. We are back at the Responsible AI Summit. We had a little break, and in the break, we have now traveled from Europe to another continent. We are in Nairobi, in Kenya, on the continent of Africa. So we have already been on 4 continents today. It's an amazing adventure. We are joined by Diane Kemunto, who's going to talk to us about data privacy and data privacy principles. And this is a very active round, so we want to really encourage our audience out there from around the world to put some questions in the comments, challenge Diane. Don't be shy, make them hard. She is a very, very much an artificial intelligence expert, especially when it comes to the data privacy issues. But for now, Diane, if you could, please introduce yourself, talk a little bit about what your focus areas are, and then we'll get into some questions. Thank you so much.
Thank you so much, Clara. Good evening, everyone. Kenyan time is 5:30 p.m. So good evening, good morning, good afternoon. My name is Diana Kemunto from Nairobi, from the Association of Privacy Lawyers in Africa, which is a non-governmental organization that mainly deals with creating a platform for advocates, especially beginners, experts, and even intermediates in the data privacy and protection field, and going as wide as it can get, with us being able to implement, incorporate, and even embrace the new issues or emerging issues that come about with technology in the legal industry. So today I'll be taking you through what are some of the data privacy issues, rights, principles that come about with the training of generative AI. All of us know what generative AI, we have used it, we have encountered it in more than several scenarios since last year, some in cases, some in our usage, some in the papers that we have read, we have written, and even peer reviewed. So yes, I'm looking forward to a very interactive session. Keep it open, keep it hard, keep it soft. Ensure you have your questions ready so that we can have a Q&A at most of it, because I'll be highlighting all the questions that you'll be stating. I may highlight some of the issues. I may not cover what you have in mind, but the comment section is open for more interaction.
Fantastic. And while our audience are typing in their questions, I want to kick off with a question for you, Diane. Is that we've spoken a lot about data privacy around the world. Many countries have regulation and guidelines around data privacy, some better than others. But why is it that the issue of data privacy is becoming more pressing with generative AI compared to other types of AI systems? What's the difference there?
I think one of the difference, or one of the key issues that comes about with generative AI is the issue of indeletability or immutability. Most of this data which is collected can't be erased, or rather can't be deleted. So once it's collected, it's there for life because of the use of the LLMs. So this data remains there. You can't enjoy the right to erasure, which is one of the key principles in data privacy and protection. So if I can't enjoy the right to erase my data, that becomes a key issue. If I can't enjoy the right to be forgotten, then that's another issue, because I'm just using this for this particular reason. Some of the information that is keyed in is very personal. And we can see one of the challenges that comes about with generative AI is it is not, the data collected is not de-identifiable. The data is very identifiable because they use the LLMs to be able to account for how this data is collected, where it's coming from. So we get at a balance where they want to keep account of this data and make it more identifiable rather than make it de-identifiable. And that brings another issue of how can we balance between you as the user, or rather the data subject, enjoy your right to having this data to be deleted after you're done with it or after it has served its purpose, and them being able to have this data collected so that they can be able to have an account of what versions their generative AI have come about. Or we can see the growth of it from ChatGPT 1 to 3.5, 4, 5, 6, 7. So mainly they keep this data to ensure they can account, or rather they can monitor once such has been deployed in the market industry. Yes.
Thank you so much for that. It brings to mind a question about the recent case with LinkedIn, where people who have profiles on LinkedIn realized that much of the data was being used for training AI. And subsequently, there were some legal challenges, especially in the UK, but also in other parts of the world. LinkedIn, of course, is an environment that's built for professional communication, networking. It's a place where people learn new things. It's also a place where you make contacts in different industries, and it's a great place for professional growth. And people have a lot of personal information in there, what schools they've gone to, what grades they received, and where they have worked. What are some of the things that you think, like takeaway lessons that AI developers and companies should take away from cases like this, where the users haven't been informed, and there is this sort of little gap for organizations to go in and sell their data? What are some key takeaways, do you think?
I think the first key takeaway is that the data user, or rather the data subject rights, are at the core of it all. At the core of it all, there's this generative, or rather these companies should be guided by the principles that come about with data privacy. We have transparency, we have purpose limitation, we have time limitation. We all have this, even the data subject rights is one of the principles. In the instance that such companies that we hold so much trust in them misuse, or rather take advantage of us as the data subject in making their work better, which is a commercial interest. The another issues that comes about is the commercial interest. I don't gain from it, they gain from it, they use it without my knowledge, without my consent. And this is quite a lot, considering we are living in a very technologized or even advanced digital era, where people are quick to know what are you using this for. So one of the key takeaways is they should respect the rights and ensure that compliance is as the key of it all. That is one thing. Another thing is to ensure privacy by design. In the instance that you're planning to use this data, or even the generative AI, how about you implement this privacy in from the word go? If you're using on LinkedIn, ensure that LinkedIn has a mechanism on data privacy. In the instance that you need to use that data more than the purpose you had informed earlier, there is a way you can communicate that to the data subject so that they are able to understand, okay, this was the first time this was the purpose, but now they would like to make it, to use it for another purpose. How about we communicate it to them, and we make sure they are aware of such? Because once you ignore such, or rather act ignorant is the word, that's where it sprouts legal challenges like the LinkedIn. And it was such a shame that, sorry to say that, it was such a shame that LinkedIn, we trust it so much. We share our experiences. We do everything on it. You share your workplace. They can even, with such information, someone can even actually trace where you work, the location where you are, even from photos. With now the advanced technologies, we can pinpoint such personal information. So for them to take advantage of such was such a downfall on them, was such a down patch, which we as data privacy experts were quite appalled by it. Secondly is the well, in terms of when you're using such data as a company, you have to create mechanisms like, how do you audit the risks that come about with such? Because a lot of companies will use this data, but they haven't evaluated the risk that come about with it. In the instant that it's come to the limelight of how well this someone knows, or even it only takes one person disclosing such information for the whole world to know. And once the whole world knows it, we are in a slippery slope where we'll do more research, we'll dig and find out that maybe this information has been used since the commencement of LinkedIn. It's just that recently it came to light. So that's another thing. And I think they lost a lot of clients, or rather users, with such, because we are all thinking, what more are you doing this? You collected it, you used it, we were not aware. What more what more are you doing with this? And why do you find it very necessary for you to actually collect and use this data without our use? Considering if it is something positive, we would allow. If it is not positive, then that's where the issue comes about.
Yeah, there's a lot to unpack there, and really, really amazing insight. I agree with you very, very much, and it brings to mind an issue often debated about consent. You know, how the user, the end user, can give consent, and I often say it's not consent that they need to give; it's informed consent. They actually need to know what they are agreeing to, and it becomes incredibly complex if you think of that on a global scale. And when you think about it in terms of age groups, I remember on my last trip actually to Nairobi, I wanted to take a photo. I asked for permission to take the photo because it was a mother and her child. And I said, "May I take a picture of the two of you?" And she says, "Of course." She knew me well. And I said, what do you know about what I'm going to do with this photo? Do you think I'll put it on social media? Will I keep it for myself? And she said, "Well, I don't know." And I said, "Do you know what happens if I put it on social media?" And she says, "No, but that's okay. I do that." And I said, "But do you know where that image goes?" And she said, "Not really." And I said, "I'm not going to take a photo, but and if I did, I wouldn't put it on social media." But I was trying to explain to her what she was agreeing to, and she was very confused because she really didn't understand. And so she had consented, but in actuality hadn't given informed consent. So my question to you, Diane, and I know this is a big one, but how do we define informed consent in the context of using personal data for training AI? Are these consent mechanisms that we have, like terms of service, are they sufficient? If they're not, what's missing? What more do we need to do? Or if they are sufficient, could you explain how they meet the standards that we should aim for, not just locally, but also globally? It's a big question, but take a stab at it.
Yes, it is. It's quite a big question, and it's quite a very itchy subject, considering that most of us, we say, they didn't ask for my consent, or my consent was given, or I gave consent. I think one of the, before we even reach to where we are training on training generative I think we should first identify, what do we, when someone says, "I want your informed consent," or rather, when we're trying to get consent, how well is this consent? How well do we understand even what the term consent is? Consent is the willingness for you to actually give out information, or even to participate in anything, or even for this, for any party, any information, whether it's a picture, whether it's a book, whether it's anything, you must give out consent. So when it comes to informed consent, when it comes to generative AI, informed consent means that this company, or rather this application or this model, have informed us of, one, the purpose of collecting such information. What is the reason? That is one thing. How long are you going to use this information? That's another thing. What are some of my rights that comes about with me giving out such information? And what are some of the responsibilities, or rather the obligations, that the data collector, or rather the data handler, will have with regards to the information that I'll give? Will they take enough measurements to actually protect it? Will they take enough measurements to actually act within the parameters of what we have agreed on? Because a lot of times, when developers or companies collect information, they will say that this is the purpose, you're going to use it for this for 1 year, or just for a few minutes, or for just for this purpose. But then you find out that this information was collected, was used for more than the purposes that ought to be have been used. The secondly, there's the issue of the retention. They retain this data for more, years than what was expected, or rather than the agreed amount. So with informed consent, we have even to agree what is the essence of you collecting this. Even before we reach the purpose, I'm collecting this information because this and this is happening, or we're trying to make our version better. So the only reason you're collecting that data is to ensure that whatever generative version you're trying to make should be better. So once you have completed with making it better, what comes about it? How well are you going to store that data? Maybe are you monitoring it? What are you going to do with it? That's the second one. Then we have the issue of storage. How are you storing this data? When you're storing this data, is it enough? Are the mechanisms enough? Is it going to be present for the whole time? Since even after the world has ended, how long do you intend to store this data? How long do you intend to use it? How well are you going to store it? Which mechanism are you going to upload it? Are you going to print it and have hard copies of it so you can maybe study? So that those are some of the things that bring about or form the fundamentals of an informed consent. You must have knowledge sufficient. That knowledge must be whatever information they provide you in order for you to consent to a reasonable person. As advocates, we say to a reasonable person. So, to a reasonable person, that information should be sufficient. A reasonable person can be a child, not a layman. For some who are not even in that field, they should be able to understand and say, yes, I do understand what you're saying. Yes, and I do agree, and you can use it for the purpose or even for whatever you want to use it for because we have an agreement. So we can look about the issue of a data protection policy because most of the informed consent comes about when you have outlined in order some of the principles that will guide you so that I know once I'm giving you whatever I'm giving you is going to be in safe hands. So I have to ensure there is the issue of data safety at the core of it. So mainly, I think that's the main thing when it comes to informed consent. And one of the challenges I think that we face is that most companies, in their terms of reference, they tend to avoid the issue of informed consent, or rather, they try to pin it in some statements so that you will be too tired. They make the terms of reference too bulky for you to even to bother to read. Because if I want to access something, let's say on my laptop or in a website and I key in and that's when they're asking me about cookie preferences or whatever necessity I need to sign in, it becomes a hurdle because I'll just agree for me just to be able to access. And that's you see now that's another downside because if I can't agree, I can't be able to access the website. So I just accept the terms and condition out of ignorance or out of need, out of necessity for me to be able to access. And then that's when you go about and read it, that's when you read the terms of reference in your comfort, you realize you gave such company so much authority on whatever they're going to use because they can access your location, they can access some of the things, they can even access some of your history or some of the things you do, even the image part of it. They can go to Google and say, okay, this and this and this was keyed in. So let's see what was happening or what are some of even recent history and all that. So you see, that is another challenge that comes about it with these companies. I think they just endeavor to take advantage of us who are in need. We need to use your website. You can make it more user friendly rather than making it hard and bulky and tough and use of certain terms that are quite big for even us to understand. And then you see now you have access, you have authority. I can't even bring a claim against you in court, or rather, if I am to bring that claim, the chances of its success is quite low since I already gave consent. And that's what happens with this a lot of lending companies when they start now calling, or even when you go to the hospitals or other certain forms you sign. We see the issue of the WorldCoin, what it brought about, and the issue of informed consent. Because a lot of these cases, all right, a lot of these cases form precedences for us to use. Since right now we don't have a lot of cases, so whatever any country or rather court decides, we go, we read, we understand the rationale that came about it, what are some of the guiding principles that came about it with regards to informed consent, and we see Kenya was one of it. Because with informed consent, we really went to court, and which led for it even to be banned. We looked at the companies, are they data controllers, are they registered, what do they do, what is the intention of the information that was collected using the personal identifiables. And we found that there are so many loopholes that came about with it. And I think that's when we really started becoming cognizant of the importance of defining informed consent.
Yeah, wow, it's so complex and I think incredible, the range of issues that you're able to bring into the conversation. And I think the case with Kenya brings me to the next question. I am located in the EU, and of course, we are subject to the law of GDPR, and we have little boxes popping up all the time asking us if we are consenting to cookies and or not, and we have a certain AI that we simply cannot access here. And we have many people who simply just click, as you say, to get on the website or see what it is that they need to see. Because in reality, not being able to access something digitally, it also means exclusion. So it comes with the cost of your private data, your private information going out into the world, but you're also excluded if you don't give up the private information. And I think there's the catch. So I wonder, many countries are updating, many countries are proposing new data privacy regulations. Even the GDPR is being looked at. The EU also has a couple of new laws. One went into force just a few days ago, one went into force in August. But are these new movements in the different countries, are they sufficient to handle the challenges that are now posed by generative AI? Or do you think that we need new regulatory frameworks in order to address these issues? What are your thoughts on that, Diane?
I think when it comes to data privacy, the laws will always change. There will be a constant need for it to be amended, for regulations, because the scope is growing each and every day, wide and wide and wide. Even the European Union AI Act just came into force. We're still even trying to understand what is it saying, because we can also see the California Privacy Act on consumer. Most countries, I think, are just doing it progressive, slow but progressive. And I think if I say we need new laws, we'll have multiplicity of laws, which is another issue. I think what we can look at, have we exhausted the current mechanisms, enforcement mechanism or implementation mechanisms? Have we exhausted them so that we can have a need to actually have new regulatory frameworks? Or do we need to have legal notices rather than create a whole new law where we have regulations? Regulations are much easier. They come into force when we have an emerging issue, or rather something that is very commanding, or rather needs the attention. Because if we continue bringing new regulatory frameworks, we'll need to have institutions. We already have institutions. For example, in Kenya, we are yet to create a law on artificial intelligence. Currently, the government just came around with the issue of a working group, rather a committee on artificial intelligence, so that they can go and discuss and see what are some of the areas to address. And I think maybe it will come into force after 1 or 2 years. Kenya will take a lot of time in discussing such issues, coming up with them, writing them in the language of Kenyan legislations. Our Data Protection Act is still young, came in 2019. It's still young, and we are yet to even exhaust whatever it's providing. Tanzania's came this year. Uganda came around 2022. So as you can see, most countries, I think, are just progressive. We are all having the challenge of borrowing it from the GDPR and the EU Act, considering that is our primary law globally in terms of data privacy, and artificial intelligence. Because right now we have generative AI. The next thing we'll have something different. The next year we'll have something different. We also have the issue of Bitcoin. Bitcoin, then the issue of bots. Bots are automated tools. So how do we go about that? How do we cover automated tools in blockchain and creating that merge? How do we go about such issues? So I think we can do progressive, try to highlight what needs the most urgent, what is most urgent to us, what is more compelling that needs our address immediately. And I'm glad we have the EU AI Act right now. So that is something we can try to first understand. What is it saying? And what are some of the areas that have been covered there, and what is it lacking? So that we can be able to fill that gap, so that we, in the next issue, we don't have such issues. So these issues that will be already addressed, or even go about collecting data, or even call for papers publication, so that we can have a unified regulatory framework. So considering the AI issues are the same, what is going to impact you in your country is what is going to impact me, because we all have access to the same generative AI. Yes.
Absolutely. I think you point out something very important, that, everybody is working on their own regional regulations or country regulations, but this is a global impact, regardless of whether the population is hooked up and digital or not. It's a global impact. We have just a few minutes left, Diane, but as a finishing or sort of closing reflection, I'm wondering, in your opinion, what's the most critical steps that companies, regulators, or even individuals can take today to ensure data privacy in AI training?
I think the first one is the privacy by design. I think that is what will work best. And another thing is we have the stages of how generative AI is developed. We have the design, the fine tuning, the deployment, the monitoring. How about such companies provide that report to us, the users? We can have access to their reports on what they're doing, on what they intend to do, or rather from the research they have done, from the information they have collected. What are some of the information that is necessary? How did they use this information? How did they integrate it into the system? And why is there a need for them to use personal information? Because we need to also understand, because we'll have questions like, why are we doing this? Why do you need my personal information? They need to have a report, they need to have accountability on all the actions they're doing. And another thing that companies can do is the use of such mechanisms such as sanitization. When they collect such information, they can siphon, or rather they can sieve the personal information and just remain with non-identifiable information. Once they are already done, they can just have something like a skeleton of this information. They know what that information is, but make it inidentifiable. Don't make it so obvious that this belongs to Microsoft, because if I key in data and it's like, oh, Microsoft is there, and we also have the references, it makes it more identifiable, and even puts that company at risk with regards to even hacking and all that. And another thing I think is, or maybe is, I don't know why we need to label AI as responsible. I don't know why we need to label AI as ethical. It's from the word go. AI should be responsible, AI should be ethical, AI should be good naturally. I think naturally from the word go, because right now we are here saying let's make AI responsible. Why are we trying to make companies comply with laws that they already know they should be compliant with? Why are we saying that AI is ethical? Why are we saying that explainable AI? Where us as the users have to be able to trust you as the company developing that AI. Why not make it natural, or rather obvious for us to trust you? Why not make that AI ethical so that I don't have to take you to court? Yes.
Very good point. I have wondered that myself. And I think it goes back to what you started with saying, really about building privacy into design, to think fundamentally that, of course, AI is ethical, of course, it's responsible. And that's our starting point. And then the rest will follow. I think incredible insight. Diane, it was lovely to see you again. We must catch up more next time I come to Nairobi. I will catch you up and we will have a cup of coffee and talk data privacy. I'm thrilled about the work that you do both in Kenya and beyond. Your insights are always priceless, and I really appreciate you taking time to join us today. Thank you so, so much.
Thank you, Clara. We'll see each other again in the panelist session. So, yes, looking forward to it. And everyone, thank you for joining. I didn't see any questions, so we'll proceed. All right, thank you.
Thank you.